All too often, companies, employers in California receive imprecise and incomplete advice about what at-will employment means. These law firms tell their clients, the employers, that at-will employment is very simple. It basically means that you can terminate any of your workers for any reason, fair or unfair, or no reason at all. And when they ask you why you're terminating them, you don't even have to provide them the reason, because there is no legal obligation to explain why you're terminating someone. All this is true, but all this is only partially true. The full definition of at-will employment is that, yes, you can terminate any at-will employee for any reason, fair, unfair, or no reason, except for when there is specific evidence that the true reason for termination is discriminatory or retaliatory, meaning because of that employee's age, race, disability, sexual orientation, national origin, or because that employee complained about unlawful harassment or engaged in one of the specific known protected activities. And what matters in these types of situations is not what you think, is not necessarily what you feel you terminated your employee for, but what that employee can show, what that employee can show to his lawyer, and what that employee can present in court to make it look like he was terminated, not because he was not good, or not because you had a layoff, but because of his workers' comp claim, or because he asked for a disability leave, or because he complained about unlawful racial harassment, and so forth. So, you have to know that yes, at-will employees can be terminated at any time for any reason or no reason. But if that employee can show that the reason, or at least one reason for his termination, was illegal or might have been illegal, then he may have a claim against the business, against the employer, against your company. Now, let's talk about providing a reason for termination. It's true that you don't have a legal obligation to explain why you're firing someone. And in some cases, it's actually a good idea not to provide a reason, not to go into details. But in other cases, it's not a good idea not to provide a reason, because it only makes the potential wrongful termination case of that employee stronger. Let me give you a very simple but very classic, so to speak, very common example. Let's say you have an employee who worked for you for 5 years. He files a workers' comp claim. And already before that, you noticed maybe that he was stealing or he was making too many mistakes. And you were ready to terminate him, but you were not in a hurry. And now, after he files a workers' comp claim, you, in your heart, you say to yourself, you know what, I meant to terminate this person anyway, so I'm going to terminate him now. And let's say you terminate them a couple of weeks after they file a workers' comp claim. And when the employee asks you, why are you terminating me? You don't feel like going into details. You don't want to confront them. You don't want to talk about their mistakes or their theft or maybe whatever violation they committed. You're telling them, you know what, I don't want to give you a reason. That employee then, after being fired, he goes to a lawyer and he says, I've worked for this guy for 5 years. I filed for a workers' comp claim. A few weeks later, I'm being terminated. And not only that, but my employer would not even tell me why I was terminated, which suggests all the more that the reason for termination is my workers' comp claim, because he could not articulate any other reason. Then later, when that employee files a lawsuit, you all of a sudden come up with all the reasons for termination: policy violation, insubordination, theft, whatever else. But then the question is, how come you never warned that employee of any of these problems? How come you never brought it up even during your termination meeting? Why are you all only bringing up right now? You may win or you may lose that argument, but certainly in this type of situation, not providing the reason for termination is not going to help you, and it's only going to strengthen the case of the other side, of the employee that you fired. So what's the bottom line? There is no universal rule of when you should and when you should not be providing the reason for termination. Every situation has to be evaluated in light of its own unique and specific facts and circumstances, like many other things in law and specifically in employment law. Thank you.